5 minutes after 2, live on Asempa FM. Ekosiisen is here with us again, Thursday afternoon, the 11th day of February 2021. So it's official. This is Ghana's biggest and the most authoritative political, social, current affairs talk show, Ekosiisen Live on Asempa FM. All talk all day. The multiple award-winning late afternoon political talk show, Ekosiisen. I speak on behalf of the best production team in town, a team led by Dominic Kisi Yaboa, with support from Nana Chum Berema, Jackson Osei Ntiamwa, Eric Opare DJ Ayo, and a Queen Star at Japan. Yet not to say it's 4 hours 30 minutes into 2 p.m. to 6:30 p.m. And says the Supreme Court at Nasiria, the attention of the nation turns onto Ekosiisen because yenina yababitie and how we bit me break issues down. Na one and some the found one any won't be in como now on suenya huntias ye papa. Intiana Yasinat Nasi, the Supreme Court ama another ruling. Yebeshani Yakum na yashe. The details of that ruling and what you have to know going forward, no impact on the case. And then already, the petitioner, John Dramani Mahama, a lawyer for a file fresh application at the Supreme Court. The Omu Penyan said the court should allow them to reopen their case. And Muamu share, Utie wa Sempa FM, Otie say lawyer Tachusi Katamasa indication, no, said they would want to seek the leave of the court to reopen their case. And that application has been filed. Yebekum na yashe details of that particular application. And some a court ni ruling even before the filing of the application. The court ni ruling by again another 7-0 unanimous decision. So opposition lawyer Chachuche Kata edema the decision of counsel for the first respondent and the second respondent say omonso person mu close your case. Now they don't intend to call on their witnesses to come into the box. Lawyer Tajusi Kataka said, "Enyadi omufuasu ebiye." Court needing a ruling by and unanimous decision and omabo. Lawyer Tajusi Kata argument ni nyina egu baby. Yebeshani yakoni nyinemo edi and what it means to the case going forward. And that's for the Supreme Court. Now beyond that, there are some other trending stories. Yebeshani to me akum. Ministerial veteran and so Koso Din here in Accra, live from the Parliament of Ghana. And the Defense Minister of the Republic is before the committee. Enra Obekaya, Health Minister by, National Security Minister by, and the Defense Minister and one other minister, Meshana Midinidino, Etumi Atuja Amamo. Okay, the Education Minister designate would also appear today, and that promises to be another interesting veteran session. And the Defense Minister and Education Minister, Ebesha said the Nyoma ABC Ako. And Timunshanenson, MIA, Yawon Komo Bebrina, Edifas Ansem Nina, Ben Salah Najim, or say, good afternoon, Obi, and your number one political program. Keep the good work you're doing. Well done. Thank you, my brother. One Fabi, I will share your free account. David Techimenson, I see you watching us live. Yunus Osman and so Yehun Silas Odum is also watching us. Shady Praise Beidu Bafo Obosiako. Wow. Yawana Kiamwa Boaten also watching us from a Blekuma Central. Isaac Mensa all the way from the Wassa East District in the western region of Ghana. Bafo, okay, I think I've mentioned the name already. Francis Williams, and so Nipa your Facebook Live na Edorso. Yadamunya na ase. And one platform I will be to me following apart from affiliate radio stations ninyanano. Were over a dozen radio stations that fire in Jumedie live from Tamale right down to BBN in the Western North region. Oko Facebook with my share, Oko YouTube with my share live. Follow us, our live tweets on Twitter, on Instagram, and so with me following. And let's stay interactive. Just come through with your thoughts, your comments, your observations. Would love to hear from you. Yen Shadan Saimre, Yen Kwa Homane so Joseph Akable, Yen court correspondent. Joseph Akwaba na pom to saying. Fantastic. Me minim say and it was quite an interesting day in court. Ni nyina ye hwe nim say court anyone ruling ebeba for the first time. I think this is probably the longest ruling in terms of speech. President of the panel Ede Atuja which means we know quite detailed highlight of the ruling no na the
Edika court no indicates in terms of the question that it set out to answer in the ruling, no, and then they say whether or not the respondent can be compelled to give evidence, i.e., say yatri obi akoda in court na ono wan kasaka say obeka ne numa sem na enu echi na fe o se on kan numa sem bi ma court ne betumi aforce no so on koso no on ko box nim sana be ya ne num sem no omo be accept na fe ne echi no other parties in the case let me be the question and the court betumi aforce ni panel. That's the question that the court set out to answer. The first thing that the court said was that the witness statement, Peter McMahon were filing, it does not constitute evidence until say witness never be ra at that kind of now boko na man say opese ojina ne witness statement about filing so no as evidence our court ne emfanye djuma ewo adjudication of case na edan enim no after so biom court no eka said the positions in affidavit in opposition to interrogatories cannot make respondents compellable. Obekaya, ora chasikata ebo court na manye say, embra na EC chairperson oppose or more request for a review of the interrogatories ruling no, or indicate these are questions on bisa mubisa no metu bisa no ewo cross examination. You know, Mr. Chikata say by saying that no under oath no, it would have meant that we elect to say about the that can no mubisa the questions. And then a court make us such depositions no in affidavit in this instance interrogatories review no, it doesn't mean saying me court in the power to force someone to go into the box to be cross-examined. After the court may say or any laws passed by Parliament no, none has been pointed to show that the EC chairperson is subject to different rules contrary to the settled rules of procedure and settled practice. Court to me so betumi awada obi se onko enko dina da kamindia dance wa bra ni panin pese obeyesa court na sign make comment say a petitioner's case obi or the court or the asama court in this instance no say ebeye ye anase nyeye no ejina strength of sani pana evidence or the akodan court na kache nenye evidence omo a wa file asem na against no omo de ba dan court no akache and I think so of the case na Mr. Jikata referred to no, in an example, it says secondary case near the those cases, no, by way of fact, no, and in terms of the issues and the ratio that the court arrived at, no, they do not apply in this particular instance into distinguishing from those cases. And I think so. The court cannot compel a party to give evidence, and that was the conclusion of court, no, arrived at or ruling on this particular issue.
And what it means is decision. Counsel for first respondent take you know say man ne witness emma box name no court now uphold this decision no. Great. And yenim say enu wie ye na omu nyina das no lawyer Chachuchi Kata sign sorry and even before so be sorry kra eden nsem atudwa no court na ekobai eka say omu ba be ma how our trial no ebeko going forward na almost say den importe.
In fact, even before court never sorry no, or the kind sorry but court na man say when say court no airport ababaka be taking decisions about how things should proceed, but he has a number of applications they are in the process of actually filing into one or say it's a review of decision na court na render and I think so they'll be seeking to ask the court that it allows them to reopen their case in order to ask for an order to compel the AC chairperson to come and be and be asked questions by Mr. Mahaman's side. Into court na money. You know, court can say it's a court of record. Into what as it stands now, it's proceeding because there's nothing on record. Into no court in sorry quiet back and my ruling. Directions some of them mind say closing addresses are to be filed simultaneously, i.e., all the parties in the case no or filing or closing addresses at the same time on or before February 17th. What the closing addresses does, they say, it's a summary of the lawyer's legal points in terms of all what has transpired in the case. They will be analyzing the testimony that have come up, the cross-examination that has been done, and make a case for why they believe the questions in our court next setting for trial, why they believe their view has been answered or the other side's view has not been answered. And see, that's what they have to do in their written addresses. Then on the 18th of February, I'm about to pay more court, and they'll be given the opportunity to orally address the court on the highlights of these written addresses are more a filing. Now, you know, na court no journey for judgment. Now, after court na master directive, Mr. Tikata court na man say, mobile filing for one, a request that they be allowed to reopen the case and now things to be on to a review of this particular ruling. And if need be, they would have to ask for a stay of proceedings as well.
In TCC, you expect to say 2 applications. The conk certain CC or my file the application to reopen their case. You name say, I know your first headline was or more across in that same application because me kind application now and no more file now. It is clear say they want to reopen their case for a single purpose. And purpose, and it's almost sapini the Electoral Commission chairperson to the court. And for example, so what kind paragraph, and we're only in 39 paragraphs. 39 paragraphs. I'll share paragraph 38 now. Ekase, I am further advised by counsel, and this is John Muhammad, the petitioner, speaking. I'm further advised by counsel and verily believe that after a subpoena is served by my lawyers on the chairperson of the Electoral Commission, if she wishes to invoke, for instance, a witness immunity such as protection against self-incrimination or any concern about violation of her human right, she will be entitled to put that forward for the determination of the court. And wherefore, and this is the final paragraph, wherefore I swear to this affidavit in support of the application herein to reopen our case for the specific purpose of serving a subpoena on the chairperson, Mrs. Jane Adokwe Mensah, to come and testify before this court. And I initially thought first will be the application to reopen the case, and then later on the application for subpoena. No, but now we no more community in our boom. What do you think?
The Omayane say omo bokot na manye because on say as it stands no. The way the case na to me and make it order for the subpoena not to go through.
Yes.
And see what they are doing now is in fact we did the initial part now. It indicates that of course paragraph 18 now say I am advised by counsel and verily believe that the subpoena documentation to be served on Mrs. Jane Mensah is ready for filing.
Oh, okay.
Once leave
is granted to reopen our case. Okay, I've seen that.
The mobile court now, man, the court the maho kwanya, and then 10 pounds on the file and so.
Okay, and what it means, it was a lawyer Tajuche Kata argue before the court reasons why on person reopen on case. Say court neji anu tumua na afi on my file application for subpoena no.
And unim say o file case be processes no so registrar no fix date into share document no page 1 na date no fix for 15th day of February 2021, which is Monday, which is just about 3 days before the court comes back to hear the oral submissions on the written addresses. And that is how it looks for now. On Monday, also we'll come back to court Monday in order to have this particular application moved. And
there was a motion on notice for leave to reopen case of petitioner to enable chairperson of Electoral Commission to testify. And after first paragraph, second one is a court to be moved on Monday, 15th day of February 2021 at 9:30 in the forenoon or so soon thereafter as counsel for petitioner may be heard. And 15th, the court never determine whether to allow them to reopen their case and now say,
that is so. Now, I know that and if the court allows that, then it means that they will now have to file the subpoena. No more say, "Are you ready?" No. Now, and no, if they have any other request, now
no, but meanwhile, no, or more written submissions, no, dear. I will say drew court by 17th, no.
That is the case, and I'll be kaya. Or earlier, no, the court indicates in line with the CI 99 expedition theory, no, the age money I don't know. So my order, not say win this one because of your thinking that what filing process be and I be beginning they say reserve the right to strike out the petition. Obviously, the expectation will be that the law, all the parties in the case will abide by that directive of the court, pending whatever process it comes up. And in fact, the Chief Justice did indicate today, say it's a court of record, and whatever process that is filed, the court will appropriately deal with that as well.
Yeah. The interesting bit about say my file my final submission, which is supposed to tell the court say so far the akoso nyina no metimia establishing my case relative to issues a court nankasa set it down. Now still I'm pending applications be an impact on my final submission and then they be play out saying
and the it will mean that at this stage legally it's a court name or coin say case and legally the case may close, so you just have to go ahead with the process. And so what would happen is if the court gives you the opportunity to reopen your case, then obviously they would have to place a request to remind the court that once we are now making a request to subpoena someone, it will be important to court best train the BA. So even with that, in that sense, it will still mean that you have to go ahead and even file the written addresses, because
now later court now amend it.
Because even subpoena and automatic court.
Of course.
He said if all that goes through, then eventually now be court. You have to now be given leave to now go back and amend the original filing, because now the ACJ person is coming into the book to now cross examined and they are terminating the proceed the case properly, and that will obviously mean that it will even change the dynamics of the case. Will the respondents also be asking to call some other witness, or would they also be calling down?
So far, on my indication at least, and lawyer could upon Chroma Kai say amongst counsel for second respondent, also join say court ne grantee no dia also ebe subpoena say petitioner nankasa metina box name.
That's a very interesting point. Make you and see it's not clear how both sides believe that the other party's witness can help their case, but I mean the court has already indicated today that a case by a petitioner succeeds on the evidence
and the strength of the petitioner's case and not the weakness of the opponent's case. Great. Ma menase na yemfa insi. Yebehwe se yebenya a lawyer fo ni bi ene won wedi nkomo account and then bibia ne yebesan so aba ho. Why? Meda sepa Joseph Akable ena motene nkanenti enne said the lawyer Tajusi Katama indication wo court no say omo bepe kwan asan file a fresh motion this time no almost record there's a court ne ma won kwan na omo case omo ka so omo close no omo nsan MBA